talk about thousands of years of law and history in just 30 minutes or less. So, many thanks to Doug, to y'all for being here. We talked about one of my favorite subjects. So my favorite, is defamation. What's defamation? Is it how to destroy a person's reputation and get away with it? Is it, no, not that. No, how to kill an industry, the only industry that's protected in the Bill of Rights. Is that what defamation is about? Or is it more about how to protect your reputation when unfairly damaged? And maybe it's more about how to ensure that we protect our national commitment to robust debate about issues of public concern that are necessary to free and open debate that underlies our democracy and populates the marketplace of ideas. That whole idea of marketplace of ideas is the foundation to government of the people, by the people, for the people, and is also an engine for truth. Put all the ideas, good and bad, into this marketplace, and the good ones will float to the top. So, anybody ever been sued for defamation? That was a different question than that. Or sued somebody for defamation?
I've sued somebody on behalf of a client.
Yes.
On behalf of a client.
Public figures, private figures?
Private.
I was not sure that the court decided they were a public figure because they were a high school football coach.
It's an interesting, that area of law is one that's in maybe going through some changes.
Well, specifically, they were the football coach of a large high school that was televised weekly on cable access. Therefore, that was enough to make them a public figure.
Your subject of the defamation was related to that?
Subject of defamation was related to their dating a former student.
Oh, okay. So you've got direct experience with this subject. Let me ask you some other questions, if I could, if you don't mind. Who agrees with Clarence Thomas and Neil Gorsuch that the Sullivan standard, it's not Rod Sullivan standard, not Sullivan standard, actual malice. Who agrees with those two Supreme Court justices that it's just a made-up policy? It's not really something that's provided for in the Constitution.
Yeah.
But there are a lot of other made-up laws we have to deal with by the Supreme Court that they don't want to talk about. Qualified immunity being the big one.
There was, I'm sorry?
Qualified immunity for law enforcement being the big one.
Yeah, so one of the things on that subject that I remember is during some debate about whether video games were the source of someone's violence or had caused a young person harm. I don't remember exactly what the case was about. So what I do remember was it was one of the justices, I want to say Scalia, but I don't think it was, during the course of the debate, interrupted and said, counsel, what this other justice asking you wants to really know is, what did James Madison think the First Amendment says about video games? And that question illustrated the problem. How do we take that Constitution written hundreds of years ago and apply it to what's going on today? Because certainly they didn't have TV, they didn't have the internet, they didn't have radio, they didn't have all these other things that we have today that they didn't have then. We'll talk about what the latest word is on that, though, that idea that this is a policy made out of whole cloth rather than something that is provided for by the First Amendment. Excuse me. Okay, so let's talk a little about the history of defamation law. I believe it was Winston Churchill who said, history is just one damn thing after another. Which is a true statement. We'll talk a little bit about the history, the elements of defamation. So, can everybody see the screen? In eons ago, there was indiscriminate tribal warfare. If one member of a tribe said something bad about a chief from the other tribe, there'd be warfare. Then that elevated a little bit to blood feuds. And then somewhere around 900 AD, King Alfred said something to the effect of, cut out their tongues if they commit defamation. And of course, in those days, it was slander. Libel is printed slander, and that didn't come along until Gutenberg screwed everything up by inventing the printing press. In the early days, there were Germanic codes and other codes that provided for some money damages. One example was that if you called someone a murderer, it was 2 pence or 2 shillings rather. If you questioned the chastity of a woman, it was 45 shillings. That's still on the books. Ecclesiastical courts, I guess those are church-related courts, handle defamation claims. They handled it as a sin. One of the punishments was you had to publicly confess your sin of defamation. And you know, where do you think that might come from? That idea that defamation is a sin.
Well, 10 Commandments, bearing false witness.
Thank you. Exactly right. And I did not prepare him beforehand. Yeah. So there's that to be said. And the Bible does say that a good reputation is to be desired more than wealth and riches. So this is an ancient principle that our reputation is worth more than almost anything. Because once it's gone, and we all know that as lawyers, and you all know that too, Greenlee, that if you earn a reputation with judges for honesty and credibility and truthfulness, if you do something to lose that reputation, it's very hard to get it back. At least that's what we're told quite a bit. Yeah, so then the royal tribunals came along, the kings, the Star Chamber in England, I think, or was it Spain, developed the idea of political libel. If you're going to speak falsely against the king, or not even falsely, but just speak some truth that defames the king, then you're going to be subject to the Star Chamber. There were criminal penalties that came along, the idea. What about today? Gosh, we're in the modern age. Do you still think you can go to jail for libel or defamation?
Not in this country, but other countries, yes.
Thank you for that answer. Gives me a chance to say, no, you're wrong. There's a chapter 836, I think, is in Florida law, still has misdemeanor penalties for libel and defamation. The last time somebody was prosecuted for libel and defamation, I can't honestly say, but the penalties are on the books, and I think it's fairly crazy, but that's just my opinion.
Up until the recent Supreme Court opinion on abortion, the abortion laws were still on the books, making those criminal offenses. So
Yeah.
there are a lot of laws still on the books that are clearly unconstitutional,
Absolutely.
but they're there. They're there.
There they are, right. Yeah, so the printing press brought in that apparently in Roman law there was this idea of written slander, which is libel. Then we started having laws about seditious libel. In this country, Alien and Sedition Acts. And I think it was John Adams who signed that law or pushed for that law. If you say something defamatory against a government official or the government, you're going to be punished. Imagine that today. Used to be strict liability. We'll get into what the standard is for defamation, standard of proof for fault. How about truth? Wouldn't truth always be a defense to defamation?
Not according to the Florida Constitution, no.
Tell me about that.
Well, can't remember what year it was, but there was an amendment proposed to the Florida Constitution making that truth is a qualified defense in Florida. And I was working for the Florida Association of Criminal Defense Lawyers. This was about a decade ago, and I was in Tallahassee, and I can't remember exactly the circumstances, but the former president of Florida State University, Florida president of the American Bar Association, Sandy Dallamard, was present to argue against somebody wanting to amend the state constitution again to remove truth as a qualified defense. So, yeah, in Florida at least, if the plaintiff can prove that even though what you say is true, you're doing it with the intention of hurting somebody's reputation, you can still be found liable.
It sounds like an amazing concept, doesn't it? I mean, if the truth is the truth, and we are a society dedicated to finding truth, Why should that be punishable under law? There is a corollary to that. It's called defamation by implication. If you state in a publication, or if you publish to a third party a statement that states true facts, but the way you juxtapose them creates a false and damaging meaning, then you can be held liable. And that comes out of a case in the first DCA, Anderson v. excuse me. There was a newspaper, maybe the Pensacola News Journal, I'm not sure. But anyway, they wrote a story about an asphalt contractor, big business, and there had been a hunting accident in which his wife died. He shot his wife. And the way they wrote the article made it sound like he had murdered his wife. They didn't say murder, it's just like the way they stated the facts made it sound, gave the impression he intentionally killed his wife, and that was found to be defamation by implication. All right, so in a broader sense, truth was not a defense until the early 1700s, the trial of John Peter Zenger in New York. He said something true about the governor of New York, and he got sued for libel. And the jury decided it was perhaps an act of jury nullification, but the jury decided that truth was indeed a defense. And since then, that has remained part of the law, which in the elements of defamation, we'll see in a minute, there has to be falsity, except in the few instances that we talk about. There has to be falsity. It's an essential element. So if something is true, false, then it's not true. All right. So where have we come? Where have we arrived? Where have we got? Can you see one?
Yes.
Yeah. So Professor Smola has written a treatise. It's huge. It's on Westlaw. Slander historically proscribed and is prevented, I believe, to clear the slandered party's name and protect the soul of the slanderer, which I guess is what confessions are about. While libel was later created primarily as a means of protecting government from the power of the printing press. And the British led the way on that. They enacted licensing fees. You had to, in order to own a printing press, operating, you had to have a license to do it. You know, it started out, right? Gutenberg created this printing press, and even before that, what was the one main source of information that most people had? It was perhaps the Bible, and that was done by monks, sitting in their desks, illustrating Bibles, and to own a book was something really substantial. Most people didn't have the money or resources to own a book. So there was one source of information, the Bible and the church. Then we get this printing press, and so there are many more sources of information, newspapers, publications, Federalist papers, all kinds of subversive things. And so the government had to do something about this. And the government wanted to control all this information, so they imposed these licensing fees. Today, at least in our country, that's just not the case.
Oh, I disagree. It's the case in Duval County.
I'm sorry?
It's the case in Duval County. We have an administrative order
Yes.
from the chief judge
Yes.
that differentiates your clients from my clients when they apply for media access to the courtroom.
Yes. Tell me, what do you mean? For
The
public?
When the judge did this chief judge's most recent order regarding media,
Yeah.
he designated out what I would call legacy media, what he calls traditional media, I believe,
Okay.
which is those that have government licenses or have been produced for years and years, as opposed to those who are modern journalists who publish their content on YouTube for
They get
clicks and-
favored treatment when it's seeking access to the court.
The legacy media does,
Yeah.
yes.
Yeah. That's been a problem for all the courts.
Well, we had that case in 2016 where your client had to come into court to get right to do one of my cases, and
Yep.
same thing with the non-legacy.
Exactly right. Yeah, I mean, a newspaper is a newspaper, right? The New York Times has always been the New York Times, and everybody would agree that's a news source. The Wall Street Journal, the same. The traditional media have been around for a long time. What about bloggers and video bloggers, and people who have podcasts. And if there are only so many seats in a courtroom, how does the court determine the court needs to have some seats for the families of the people involved, for the general public, and for the news media? Let's say there's 100 news media who want to be in a case, but only 50 seats. How does the court distinguish between what news media you're getting and which ones don't? Here's one of my favorite quotations. What if we rock with this defamation law? It's a forest of complexities, overgrown with anomalies, inconsistencies, and perverse rigidities. A fog of fictions, inferences, and presumptions. I'd like to say that's just because our judges don't understand defamation law, but many times I feel the same way. This is too complex to understand. Depends, it's a highly fact-specific set of laws that apply. So, if only, God tried to stop us from this, right? Tower of Babel, he stopped all of this, as the Bible story goes. He stopped all of us from being able to understand different languages, right? And that limited the amount of possibility for defamation, right? So he tried to help us avoid this. Then Gutenberg came along and ruined everything, created this printing press, so we all started publishing and talking. And then Marconi with his radio, and then Morse code, and then Alexander Graham Bell, and then Farnsworth with his TV, and then DARPA and Tim Berners-Lee, I think is the name.
And Al Gore.
In the internet. And what?
And Al Gore.
And Al Gore, that's right. He invented the internet. And so now we have where there used to be one source or very few sources of information or publication, the Bible. Now every person is a publisher. Anybody can publish on the internet, and everybody does. And frankly, in my opinion, it's chaos. And it's very hard to know what's true and what's not true. It used to be that a publisher in a newspaper was someone who had acquired some status in life. The Sulzberger family publishes the New York Times. They had established some position and success in life, and you knew what to make of it. No matter what kind of newspaper it was, conservative, liberal, yellow, journalism, or not, it was not easy for anybody just to get out there and start spreading information. Today it's very easy. So, all of that said, the explosion, and we'll say there's an explosion of defamation litigation in the past 10, 15 years, can be documented, and there's just defamation taking place every day. How are we doing on time?
Good. Another 20 minutes.
Okay. All right. So where are we today? The essential elements of defamation come out of, these are not new, but the most widely quoted case in Florida is Jews for Jesus v. Birk. It's a great case. It really explains in detail what the law is. The plaintiff was a mother of the Jewish faith, and her son had joined the group of Jews for Jesus. And he said something or published something in a newsletter that suggested that his mother had also joined the Jews for Jesus group. She didn't have anything to do with that. She wanted to remain a member of the Jewish faith and didn't want anybody else to think she wasn't. And she thought that would be defamatory for someone to say, "Oh, you're a Christian." She's a Christian now, no longer Jew. In her community, that's what she thought. Honestly, I can't tell you how it turned out, but I can tell you that this case it provides us with the elements of defamation. You've got to have an unprivileged publication to a third party. So what does that mean, unprivileged publication? If I'm in court and I'm involved in a lawsuit that the defendant had, let's say a high school teacher had sexual relations with a underage student, and I talk about that and present evidence about that. And let's say it all turns out to be false, but that's all privileged, because what I'm saying, those things, those words I'm saying that hurt the person's reputation, aside from the issue of truth, they're made in a privileged environment, litigation privilege is called. So we want people to be able to present facts in court, so we don't want to have people getting sued for what they say in court, so long as it's mostly related to the action by the court, action that's going on. Number two, it's got to be a false statement. And there are many other privileges, by the way, which we can talk about a few of them. Second element is a false statement of fact of and concerning the plaintiff. Key parts of that. It's got to be false. It's got to be a fact, which means the definition of a fact is something that's provably false or provably true. Of and concerning means it's got to be about an individual or a small enough group of individuals that the entire group is being defamed. You can't say all Democrats are liars, cheats, and thieves. No comment about defenses here, about the defense of truth, okay? All Democrats are liars, cheats, and thieves. You can't say that. Well, you can say that certainly, but it's not defamatory because there are too many of us Democrats to say you defame me by saying it's just the party. Now, if you say my neighbor down the street is a liar, cheat, and thief, then that's defamatory because that person is identified. It's of and concerning that person. If I say, let's give fair time here. If I say all Republicans are interested only in themselves and want to take all the money from the poor people and want to deny the rest of the world an opportunity in America, that's not, no Republican could sue for that because it's just too big a group. So it's got to be of and concerning a plaintiff. What's the standard of fault? Negligence or actual malice? For private folks like us, I don't know if any of us in here would qualify as a public figure on anything. Mr. McMurray,
was.
you were as a legislator.
Right.
You may have lost that public figure status now that you've been away from the legislature for a number of years.
Yeah.
And you have not sought to interject yourself into public debates in a broad and widespread way, so that if someone published a false statement about you as you work as a lawyer, you'd have a very strong defense against being determined to be a public figure. Private citizens, all we have to show is mere negligence. Somebody didn't use due care in publishing a fact about us that turns out to be false and turns out to harm us, then that's going to be a basis for liability. For public figures, it's a much tougher standard, and we can talk a little bit about why that is.
What about being a talking head on a news program
Right.
on a semi-regular basis?
Yeah.
Is that a public figure or?
Well, depends. Depends on what the subject of the alleged defamation is. Depends on whether the what the person is a talking head about, their subject matter. Depends if it's a local TV station versus a national TV station. But yeah, one of the key elements of the public figure analysis is that they have equal or as much access to the media to correct the falsity as the person who made the falsity. So if there's an equal ability to voice their view, then that's one of the essential key elements of being deemed a public figure.
That
Do you have anybody in particular in mind?
Well, the guy sitting over there, he's done it a few times. Rod.
Yeah.
But yeah, the question, if that's the standard, then that really, because it's been a long time since I've read Sullivan, New York Times Sullivan.
Yeah.
But that calls into question because the New York Times was not exactly taking the word or publishing anything complimentary about the sheriff of Montgomery County or any other Alabama county at that time.
Yeah.
So did Sullivan really have any type of equal access to the media? I don't know that he did.
That was, well.
I mean, he was an elected official too, so that's the thing.
Yeah.
But
There are two types of public figures. There's
Right.
The general public figure. All elected officials are, or appointed, high-level appointed public officials are public figures by virtue of their position.
And if I remember correctly, George Zimmerman was found to be a public figure when they went after him after the fact because, and you know, this was somebody who arguably had nothing to do with themselves becoming a public figure, but was, according to at least the jury, was forced into a situation of no account of his own, and he's suddenly thrust as a public figure and can be attacked at will because, well, his trial was reported.
I haven't read that case,
Yeah.
but that would fall under the category of a limited public figure.
Okay.
Where a private person is deemed a public figure for limited purposes. And that all depends on whether they voluntarily injected themselves into an area or somehow became so widely known on a subject that they are deemed a public figure. Again, having
Yeah.
equal access to media to counter whatever has been said.
Okay.
Yeah, and that's an area of law where there may be adjustment coming to revise the limited public figure status. And there was an attempt this year in the legislature. Yeah, it must be defamatory. And defamatory means not only false, it's not just false, but it's got to cause damage. What would be damage? Submitting you to hatred, ridicule, distrust, contempt, or disgrace within your community. Let's say the country club wouldn't let you come to dinner, or everybody at church wouldn't sit with you in the pew, or any number of ways that can happen. So to be defamatory, it's got to be false and actually cause injury. It can't be just something that you're upset about or don't like. And there has to be actual damage. There can be nominal damages, just somebody can be awarded $1 to say you prevailed, and we've done this to repair your damaged reputation. And the importance there is if there's a fee shifting mechanism in place, getting $1 is worth getting the fee. Teddy Roosevelt sued a newspaper out in North Dakota, South Dakota, somewhere out west, in the early days of the 1900s. Somebody had written an opinion piece that he was a drunkard, or that he had been seen drunk in public, maybe even one time. And Teddy Roosevelt went out and he prevailed. But I think the jury awarded him 1 penny, as I recall. But there again, that's what you do. That's why many times people file defamation lawsuits, because the odds are very high against prevailing, but to not do so would be to acquiesce in the falsity of the defamatory statement of someone made about you. Before New York Times v. Sullivan, 1964, the context was the civil rights movement. And in Alabama, a group paid for an ad in the New York Times, and the title of the ad was "Heed Their Rising Voices." And it was a list of, and there were a number of ministers that had signed on to the ad. They didn't know they had signed on to the ad, but whoever did the ad put them on. And there were 2 or 3 factual errors in this ad. And nobody was named individually. Sullivan was not named. He was named as the commissioner of police. And the ad talked about try to raise money to say, look, what people in government are doing to African American people. They jailed Martin Luther King, I think they said 7 times. Well, in reality, he had been jailed 4 times. They said that these elected officials, these law enforcement authorities, had encircled a university and padlocked a dining hall to keep black students out from the dining hall. They hadn't used a padlock. There was some other method. And they hadn't encircled the university, but there was a large police presence. And so, what do you think? Are those material facts? They jailed him 7 times instead of actually 4 times. Is that defaming to a law enforcement official to say that? What do you think?
No, I don't think so.
I agree. I don't think so. Same thing with the padlock. Okay, so they tied it shut instead of the padlock. They still prevented access.
They somehow blocked that.
And then, maybe there wasn't a full circle all the way around, but there were a lot of them, enough to deter, to make people think, should I go there?
Yeah, so, before New York Times we saw, and of course, the trial court in Alabama, presided over by Judge Jones, who every year, he led a celebration on the creation of the Confederacy. He's the one who, you know, the signing, or I guess the election of Jefferson Davis to president. Every year he would have this celebration. He was the one presiding over this case. And there was a verdict against the New York Times. I think it was $500,000, which is a lot of money. The New York Times, by the way, had a circulation of about 750,000 copies nationwide. 369 copies were sold in Alabama. so they tried to, the defense raised a jurisdictional defense saying there's insufficient contacts for the court to confer jurisdiction over the New York Times. Judge Jones denied that. The Court of Appeals, the Alabama Supreme Court, confirmed. It went up to the U.S. Supreme Court. And the U.S. Supreme Court said so many things. But those errors of fact were not material enough to cause defamation. There's a great book recently published called Actual Malice. And Samantha Barbas, B-A-R-B-A-S. She's a law professor, I want to say at NYU or someplace up north of all those universities. I'm one of those, so I can say that. She's a great book. It gives the history of Sullivan, the New York Times, and talks about, it was a concerted effort by officials in Alabama to put the New York Times out of business. They thought if we can get enough defamation verdicts entered against the New York Times, we'll put them out of business and they'll stop messing in our affairs down here in the South. So I recommend that book to you, Actual Malice. It gives a lot of the background. So, and they created the Actual Malice statement, which states that it's a high standard, no question about it. And many people today complain about that. But it states that in order to prevail as a public figure in a defamation action, you have to show that the false statement of fact that was published against you, that the publisher or the writer knew it was false subjectively, not a reasonable man standard, not a reasonable person standard. That you know, somebody on the street would say, "Oh yeah, that must have been false." No, the reporter, the publisher has to have known it was false, or there were such indices of falsehood that they should have known it was false. Very high standard. But the reason for that, who knows what the reason for that is?
I know it's the alleged reason is. I don't know if it's actually.
Well, let's have the alleged reason.
Protect the voice of the press, because the press has a duty to inform the public and keep the government honest.
Does it protect your voice?
No.
Doesn't protect your voice.
No.
If you publish a book and no, then
No.
okay.
Because I don't have. It's kind of like suing the Roman Catholic Church, which I've done on behalf of somebody. I mean, I still look at the case that I took to the 5th DCA. I'm like, I can't believe I got PCA'd on this. I can't believe I got PCA'd on this. This is such garbage. But it's the Roman Catholic Church, and my clients were a collection of people in a neighborhood that were annoyed with the church and the huge cross in St. Augustine. The way they were improving the land was causing flooding into their neighborhood. So does it really protect me? No, not really.
Yes, it does. I have to disagree with you again, sir.
You're welcome to.
And that's the beautiful thing about the First Amendment in our tradition in this country. If I publish something in a blog or a book, and it's a false statement that harms a public official, I am still entitled to the actual malice defense as an individual. The media assert it all the time, and it's actually not a basis. We'll get to a quotation in a minute that suggests that it's a bulletproof defense. It's not a bulletproof defense.
There's no such thing as a bulletproof anything.
Thank you. Even a bulletproof vest is not a
No.
Yeah, so, and the idea is that the court said, Justice Brennan said, the need to have this high standard of actual malice. We need some breathing room. We have to accept some falsity in order to protect more important speech. So essentially, the reputation of one person, when compared to the need for robust, open public debate on public issues, that takes precedent, because that's part of our democracy. That's the underlying thing.
I understand that justification.
Yes.
And that reasoning, but you mentioned earlier about equal access, that the public official has equal access.
Yes.
Is that something that journalists are required to give equal access, and journalists of all type, not just the traditional media, but the new media?
In some instances, yes. We have a statute, Chapter 770, that is a correction statute. If you correct a false, if it's brought to your attention within 5 days of being made aware of a false publication, you retract it or correct it or apologize, or all three. That limits your damages. But the offending publication has to put the retraction in a similar place to where the false statement was made.
Is that for everyone or just public officials?
No, everyone, yeah. And but there are two categories here. Now, public officials are public figures by virtue of their position in government. There are private people who are limited public figures by virtue of their activities in a particular area. Yeah. So, does that help?
Yes. I'm not sure that. I'm not sure that I just have struggled with the equal access where journalists would be required for anyone in the public, journalists of all types,
Yes.
would be, they would have equal access as opposed to individual in a, let's say, a publication or a newspaper.
Right. Yeah, I mean, the Florida Handbook used to say you don't want to pick fights with people who buy ink by the barrel.
Right.
Yeah.
I knew that one.
But in terms of a state
Knew that one.
legislator,
Right.
a state legislator could call a press conference, and there would be some media that would show up, and that would be the idea of the equality of voice.
But not required to.
No, not required. Correct.
Yeah, I thought you were gonna talk about damages. How do you ever prove damages in these cases? It seems like that would be difficult.
So let's take a business. Let's say, you have a business and your business falls off after the date of publication, and you can quantify that. Or if it's just a personal thing where you've been ousted from your country club or thrown out of the church or something else, or you lost a license, teacher's license, certification, something like that. You can prove that. You can have people come into court and testify, oh yeah, I wouldn't have dinner with him after I read that. Then that's going to be proof of damages.
What about, what's his name?
Yeah.
Jesse Ventura is suing Chris Kyle for the claims that
Oh, gosh.
Chris Kyle made in his book American Sniper. You familiar with that?
I am not. What did he say about it?
Well, Chris Kyle alleged in his book American Sniper that he got more or less into a fight with Jesse Ventura and beat him up.
Oh, I did see that. Yeah.
And Jesse Ventura is like, yeah, that's not true, and sued him. And well, sued his estate
Right.
because he'd been murdered by this point, but won and got a judgment in the millions of dollars against his estate.
Because Jesse Ventura's reputation was that this guy was not going to be able to
Beat me up. Yeah.
Yeah. Interesting.
Well, his nickname is the Body. So you can't let other people say you beat up the body, right?
I guess not. The jury seemed to agree.
Yeah.
Crazy.
So in 2016, I know we got probably 1 minute. Okay. Candidate Trump said he was going to open up the libel laws, chance of winning against the media because they are totally protected. That's the falsity, or that's the misconception. They're not totally protected. I mean, otherwise, why would Fox News have paid $700 and some million in a settlement? And if ever there was an example of actual malice, knowing and publishing something, those emails that Dominion Voting obtained and discovered showed that Tucker Carlson and all the other folks knew what they were saying was false. You know, the kid who had I think he had a MAGA hat on, and he was at
Ray,
Yes.
I wanted to ask you a question about
Yeah.
Ray.
Oh, that's, yeah, please. We want to hear this
the young
one.
man who sued CNN because he had.
Oh, no, you're talking about,
based off of
Nathan?
Yeah.
Yes, Nathan.
Yeah.
I can't remember the last
And
name.
the press ran with it.
Yes.
And, you know, made all kinds of assumptions. He got a lot of money. So they wouldn't have settled if they didn't think there was great risk. Listen, I'm out of time. I want to tell you, let's get past it. Must be 91, all that. And so here's the latest one. Counterman versus Colorado. It was a true threats case. And sort of in a roundabout way, the court reaffirmed the Sullivan principle, and based on this, we gotta tolerate some falsehood in the press in order to protect the more important speech, which is the foundation of our government. I've laid a lot of information on you. I'd be happy to sit down and have coffee with you, talk to you more, phone call, whatever. I love this stuff, and I'll tell you why.
This reminds me of the I've done election contests. I mean, I've represented candidates that lost elections.
Yes.
And a lot of the theory behind this reminds me of the theory behind that law. Those laws.
Yeah. Oh, interesting.
Yeah, that we're going to permit people to make claims about the fact that the candidate who won did so in a crooked way or whatever to protect the integrity of our elections.
I'd like to talk more with you. I would, because, listen, folks, I'm going to give you a homework assignment. I want you to read the Gettysburg Address, all right? And I want you to watch the movie Lincoln with Daniel Day-Lewis. I just watched it recently. Scott Sheftal, plaintiff's defamation, great said I should watch it. When I saw the Gettysburg Address carved in the wall of the Lincoln Memorial, it was only 4 or 5 years ago, and a lot of you have probably seen it when you're in high school. My eyes were swimming in tears when I read that, because it was so impactful what Lincoln was going through during the period of the Civil War. And then I watched that movie, and that also just moved me to tears. The thing I love about this country and about our law and about our profession is that, can I pick on you a little bit?
Yeah.
Rod Sullivan and I are very good friends. Our views about government politics are very different. I'm sure there are areas of agreement, but there are sharp areas of disagreement. But he and I can sit down and talk to each other, and without pointing fingers, without calling names, without questioning the birth of ancestors, right? And we can discuss this stuff. And that's what lawyers can do for our country. And we desperately have to help this country achieve the ability to talk. And talk to your quote enemy, because you're going to learn something, right? Talk to your adversary. How else could Ronald Reagan and Tip O'Neill have accomplished so much when they were in Congress and the presidency? They didn't point fingers and call names. They found out areas of commonality. They got stuff done for the people. We need to be able to talk to each other. So listen, next time I want to hear back from you. Did you read the Gettysburg Address? Did you see the movie Lincoln? I want to know what you had to say about it. Or call me up and we'll sit down and we'll talk about it.